Good morning, everybody. On behalf of the Mount Washington Valley Economic Council, I'd like to greet you to Eggs and Issues. I think Mother Nature did a lovely job for us decorating the landscape. I was also glad it ended when it ended, so that Diana didn't have a bad drive up this morning, although she took a slight tour.
Yeah, by way of name.
Made it into Conway Village, didn't take the turn. So we're delighted. We were reminiscing because this is her third trip up. She's what is your official title? Of council at Sheehan, Finney, Bass and Green, and we each year get an update on what's been happening in the employment law sector. Just before she starts, so I do want to thank again New Hampshire Electric Co-op, which is underwriting the cost of our bringing the program to you, and those of you who get your electricity, you're helping to maintain the program, so thank you very much. And without further ado, Diana.
All right, thank you. I'm Diana Wieland, and I'm in practice. I'm now entering my 32nd year of representing employers in the employment and labor area. So I've seen a lot of changes, and it's always a pleasure to come up and talk about what happened last year and what you can look forward to this year, and also to present you a program that Jim Reedy has put together for a number of years called the Top 10 Wage and Hour Violations in New Hampshire. So that's always interesting. That should be something that we'll spend a little bit of time talking about. But first I want to talk about sort of where we are. And the way that I put together the program was just to give you a few sort of examples at the beginning of what we're seeing in charge filing, both in the state and in the federal arena. Talk about a few cases. Only because they're really good cases to remind you that there are some developing issues that we didn't see 5 years ago, even though those particular laws haven't changed. It's just the way that the courts or the agencies are looking at them. And then to talk about some of the equal employment opportunity guidance that's been coming out, especially in 2013, which is very, very important. Even if you are not covered by, for example, Title VII, the Americans with Disabilities Act, or the age law, which means you have less than 15 employees. And remember, in most employment law, it doesn't matter whether they're full or part-time. Body is a body is a body. Employees, employee. So you got 15 part-timers or 15 full-timers. Those particular laws, that's the statutory jurisdictional requirement for that. Age is 20 employees. But we have a New Hampshire law that looks very much like those federal laws, and you only need 6 employees. So anybody have less than 6 employees? Okay, and we're counting full-time, part-timers. Okay, all right. What?
Including yourself?
In a corporation, you generally do count yourself. If you are a partnership or a sole proprietor, there can be other issues, but yeah. So anyway, but the interesting thing too is even if you're under that, there's some argument that public policy would limit some of the actions, including termination, that you could take toward employees. But hopefully, eventually, all of you will, if you decide to, grow, and this will be important if it's not applicable to you right today. Okay, so if you do want to ask questions during the program, I'm fine with that because more than likely somebody else has the similar or perhaps the same question, so it's a good time to do it, so as we're going through the material. If you look at the packet that I put together for you, at the very back there are 2 attachments. And the first one is the New Hampshire Commission for Human Rights, the federal fiscal year, so this ended in September of 2013. These are the charges that were filed. That's the first page. 234 charges. Now, only 222 of those were employment cases because that agency also deals with discrimination in housing and commercial property as well as public accommodations. So you can see that the largest sort of category in that is retaliation. The second is disability, and then sex discrimination, harassment being the largest within that category. You can then turn to the second and third pages, and you'll see closures. They closed about 200, 199, and then probable cause findings in those areas. Now, obviously, charges filed, closed, and probable cause are more than likely not the same cases. So this is just a good picture of their flow with that particular agency. And that particular agency, just to remind you, as far as employment goes, enforces the law, the state law that prohibits discrimination based on sex, race, national origin, religion, disability, age, marital status, and sexual orientation, because that's our state law that prohibits discrimination in those areas in employment. If you turn to attachment 2, which is this is from the Equal Employment Opportunity Commission, which is the federal organization, the federal agency that enforces a number of laws. It enforces Title VII, which prohibits employment discrimination in race, sex, national origin, color, religion. It enforces the Americans with Disabilities Act. It enforces the Age Discrimination in Employment Act. And GINA, which is down at the bottom, which is the Genetic Information Law. That's a fairly new one, and you see there's not much action in that particular law. There were 280 charges filed in fiscal year 12. They don't have fiscal year 13 numbers out. So this ended over a year ago. But there weren't many. When you look at the total number of charges, over 99,000 that were filed. They also enforce the Equal Pay Act. There aren't many cases. There were 1,000, almost 1,100 actually, filed in fiscal year 12. So that kind of gives you an idea of what's going on in the federal sector and going on in the state sector as far as enforcement. And both those laws in those areas we've talked about do require the individual to file a charge against their employer before they go to court. So this is not necessarily a reflection of the court cases that we're seeing. All right? Okay. Now, if you go to the bottom of page 1 in the material, what I want to do is point out a couple things, and we'll talk a little bit more about them in detail. There are 6 priorities that EEOC says they're going to target. And these are really important for you that have over 15 employees or 20 for purposes of the age law. So one is, or the Equal Pay Act, let me just point out, also applies to all employers, basically. We don't have any governmental employers here, do we? No? Okay. So the priorities that they're targeting for enforcement, this is a federal agency, because remember they have their own lawyers in their own little enforcement section, to eliminate systemic barriers in hiring and recruiting, protecting immigrant, migrant, and other vulnerable workers, addressing emerging issues including the Americans with Disabilities Act, the LGTB community, and accommodating pregnancy. Accommodating pregnancy under the Americans with Disabilities Act, which was a real big thing, and we'll talk a little bit because I actually gave you a case on it. Enforcing the equal pay laws and preserving access to the legal system, and then preventing harassment through enforcement and targeted outreach, so actually going out and doing some training. Those are what EEOC for the last couple of years has said they're really interested in. And the reason for those that I point that out is because there are a couple areas that LGTB issue, which we really haven't looked at as a matter of federal law because we don't have a federal law prohibiting discrimination based on sexual orientation. We have a state law. Most states do not prohibit that. So So how we got to that, and I'll talk a little bit about that in a case that we'll talk about, and the accommodating pregnancy. Those are two new areas of issue. So there was a question over here.
Can you give us an example of what is a systemic barrier?
A systemic barrier is something that, the best way to think about it is it's not a one-off. It's not a person goes out to apply to jobs and isn't hired, or isn't recruited or hired because of their race. Systemic means that there's within an organization or an industry, a cultural or a problem within the system that causes certain protected groups. Remember, protected groups are anybody who's in a race group, sex, national origin group, religious group, who's disabled or deals with people who are disabled or had a history of disability. Anybody over 40 comes under the age law. Probably anybody covered by the ADA, Title VII, the Age of Discrimination and Employment Act. And so there's some kind of issue. And one of the, I'll give you a specific example that they're targeting, and that is employers not hiring people with criminal backgrounds. You also could have, so that's a particular group, and you say, well, wait a minute, Title VII and ADA or the ADEA doesn't cover, there's no protected categories called people with felony or misdemeanor criminal convictions. But what we find when you look at our country, what you find in the, when you look at the numbers and the race, in particular, of the people and the national origin of the people who have criminal convictions, they tend to be African American, Hispanic. And so if you have a systemic issue, you have an organization who says, we're just not, we'll make it real easy, we're just not going to hire anybody who has a criminal conviction. That's a problem. We're also, although I haven't really dealt with it in here, is EEOC is starting to get interested, and has been for about the last couple of years, but has really started to get more interested in employers who have, again, sort of either specific or cultural biases against the long-term unemployed. Because depending on where you live in this country, that may be, in fact, a very specific segment of the unemployed, which may match to race, gender, but it also could be within an industry. So that, for example, if you have a construction industry in your area and you look at, that industry, or you look at that very large employer, why are there no female electricians? Why are there no female plumbers or operating engineers? So you might have that kind of, that's sort of a systemic. What they're not looking at is a disparate treatment necessarily, one person being discriminated against. But they're still filing lawsuits on behalf of individuals. Yeah.
Would it be discriminatory to restrict your hiring to appearance?
In what way? Appearance.
You tall, too short, whatever.
So
Have to have a rationale to it.
so the question is there, could you, would it be discriminatory to say you're too tall or you're too short or some other kind of category? Again, there's no protected group called really tall people group or really short people group. But when you look at particularly in gender, and that's how your example of height has come up in the past, where employers, especially, to be honest, police and fire have said you have to be this tall to be, whatever that is, to qualify even to be considered for that position, and that had traditionally eliminated women. Because when you look at, statistically anyway, in our country, women tend to be shorter than men. And what you have to, what this is always interesting to go to is, what is the rationale? And this would apply to any of you that might be faced with any sort of filtering criteria, whether it's height or weight or hair color or whatever. What you have to look at is, what is the rationale for that? And is it realistic? Or is it based on some assumption that's unproven but deeply held? You know, there's a lot of those. But when you look at them, really aren't rational, or they aren't supported by the facts. And are those then, is the rationale then somehow discriminatory? And this is a great example to show that most employers, I'm not saying all, but most employers today are very, very good at understanding they can't discriminate against women or men, you know, based on sex. They can't discriminate based on race or national origin or religion, however, et cetera. However, what they do are they take these rules which appear to be neutral on their face, but when applied to a particular group, excludes them. You have to be this tall, and if so that, for example, let's say you have an office. What is the rationale for saying you have to have a height criteria? Tall or short? If you go to height, then the question is, are you going to exclude a certain protected category? Weight. Obesity has been argued on and off, depending on the reason for the obesity, to be a disability. Prior to the amendment to the ADA a couple of years ago, most courts had said it was not a disability. Today, I'm not sure you would ever get that same conclusion. So if you say, I want somebody who has a BMI, you know, to show that they aren't overweight or obese, then you're going to very likely, if that's your filtering mechanism, you're very likely to run into issues under the ADA. So, yes?
What about just a professional appearance like if they're not, their pants are halfway down their rear end, or
Okay, a fashion statement.
fashion.
Yeah, I mean, appearance, again, you have to be really careful.
I was walking around.
But, you know, on the other hand, I have the most adorable man who's got to be older than me, who helps me at Ace Hardware around where I live. And his pants are always down to here. I don't understand. It looks very uncomfortable. And it's not a fashion statement for him. But, okay, but going to that, professional appearance, again, that in and of itself, that sounds so good. Of course you can hire people with professional appearance. Now, however, if, you know, what's the job you're hiring them for? Are they, you know, back in the warehouse where nobody's going to see them? Then I would question what professional appearance there are we concerned about. And then we get into really the more problematic issues with employers, which is, what about the people who, and then we start putting in categories that can be protected. What about the Muslim woman who wants to wear the hijab? What about the Sikh man who wants to wear, you know, a turban? What about the Rastafarian who wants to wear dreadlocks? They don't fit your white, male, 30-some-year-old view of professional, but is there something else going on that you really have to look at? But again, what makes sense? If you've got somebody working in the warehouse, they don't need to, more than likely, they don't need to look the same as the person who's going to be out selling, meeting your customers, dealing with customers, you know, that makes more sense. Now, if it's just that the person who doesn't smell very good and is wearing, you know, clothes, you know, in a certain way, but they're not fitting in one of those categories, then you probably don't have an issue. But that's the kind of analysis. I mean, think about what we just did to deal with the issue of professional appearance. So it's really important that you say, well, what about, especially about that person wasn't professional? Well, you know, I could see their underwear, I could see their bra straps, you know, I could see their everything, and that's not that's an issue. Does that have anything to do with there being female, male, black, white, Hispanic, Catholic, Baptist, whatever? So, okay. All right, so let's go on to some of these, because I think what we're getting into some of the areas that I want to address here. This first one on page 2, which is the First Circuit. Now, the First Circuit, remember, is our federal court of appeals, so we're really interested in what the First Circuit says, and this is a really important point. The Supreme Court has not one act, one discrete act in and of itself without anything else can be sex harassment. And sex harassment, don't forget, under our federal law, under Title VII, is invasive and causes taints the workplace atmosphere, let's say. And what you have to do when you're thinking about this area is look at everything that happens. So if somebody comes in and says, I've been harassed, you look at the whole, what are they talking about? What happened 5 years ago? What happened yesterday? What happened 2 years ago? That kind of thing. You look at the whole thing. This particular case actually was not a one act. There wasn't just one act. And the act, there were about 3 different acts where a co-worker grabbed, or a supervisor grabbed the breast of somebody he supervised, made sexually suggestive and stupid comments to her. So there were a number of things. And when we have touching in these sorts of situations, the courts and the agencies, whether it's EEOC or in this case the Puerto Rican organization, but it would probably be EEOC, they're going to take it really seriously. But if you look at what I underlined in that 3rd paragraph, that's the reason for bringing this sort of case up. What this court, the First Circuit Court of Appeals, said was a single act of harassment may, if egregious enough, suffice to evince hostile sex harassment, creating a hostile environment. So that's really important. Maybe it doesn't sound as important for you all. For people like me, it's incredibly important. Because again, I can go to another circuit. In fact, the 8th Circuit, the next circuit we're going to talk about on a different matter, they say that one single act really can't be. So we're having this difference of opinion. Now, in this particular case, no. There were so many things that went on. It was stupid. Okay, let's talk about transgender job applicant. Now, the reason I bring this up, this is an 8th Circuit Court of Appeals, again, a federal court of appeals in the Midwest. So doesn't apply to us, but it's a really, really good reminder that lesbian, gay, transgender, and bisexual issues are coming up in this context, the Title VII context, the sex discrimination context, not because they are protected from discrimination, but rather because we have now this new theory, fairly new theory, I should say, of sex harassment that says if the employers apply biases, understanding of what it is to be female or what it is to be male, if you apply that to somebody who happens to be, in this case, transgendered or lesbian or gay or bisexual, then that can be sex discrimination. So you are not manly enough. You're not acting in a manly way. You're not acting in a feminine way. You should wear more makeup. You should dress more femininely. You should dress, more. You shouldn't wear, this because it's not manly. That kind of thing. In this particular case, this was a transgender. Mr. Hunter was born female but began identifying as a male very, very early. And he was, actually transgender is sometimes referred to, and this is important to remember, gender non-conforming individuals, that he had a right to make this claim under Title VII. Now, he lost it because the employer actually came up with a logical business non-discriminatory reason for not hiring him. But the point is that the underlying claim itself could be heard under this particular law. This particular type of case we started seeing after Congress repeatedly refused to prohibit discrimination against gays, lesbians, transgender, bisexual, or any combination of those. So what we saw was some actually clever private sector employers say, okay, well, let's start thinking about this. And actually the Supreme Court in an earlier case, the Sundowner case back in the 90s, actually did sort of start this whole thing going with the idea that if an employer, or in that case it was a harassment case, applies these sort of stereotypes to its employee, that they can bring a sex discrimination claim. Somebody had a question. Yeah.
I'm just wondering, in this case, for example, how would the interviewer have ever known? I mean, unless the interviewee discloses in some case, other than sort of the examples you gave, you're not female or male enough dressing, it wouldn't appear that, it's not like the interviewee ever disclosed, like, oh, by the way, I'm transgender, and then, oh, we're not hiring. I mean, so what are they just claiming, that the employer figured it out during
No,
the course?
there were some facts to show that the employer knew. Okay, but for you all the way, to be honest, it's going to come up is, this is what I'm seeing anyway, and I've seen this for about the last 3-4 years, is it's going to come up in a couple ways. One is you either got a bunch of guys working on, you're in a male industry, and there still are male industries, all you employ is male. One of them starts getting teased about, hey, you're looking really gay there wearing that pink shirt, or, why don't you do this? Or you hire somebody new and he doesn't fit their view of manliness and manly men in the North Country. And all of a sudden you've got him being, even whether he's straight or gay, doesn't matter, being teased, harassed, treated badly because he's not manly. It could also be a woman. I mean, some of the early cases actually were lawyers, where law firms would say to the woman, you're a great lawyer, but you should really dress a little more femininely, maybe wear some lipstick. What do you think about that? And so it was, applying these stereotypes to a particular person. The other way it comes up is you do end up with a transgender employee who, male, wants to use the female bathroom, wants to dress, wants to come in wearing, yesterday he was James and now he's Jamie. And so how do you handle that transition? It's not a matter of just saying, no. You do have to handle it. And I think as a matter of humanity, you have to handle it, gently and humanely. And but also as an employer, you have to know that this isn't something to ignore. Yeah.
You have, in New Hampshire, you have a situation, legislation, decided has tried to pass to allow a male to go into female work.
Mm-hmm.
It's failed, but what if it had passed? Where will we be on that?
Well, I mean, today, if you have a transgender employee, especially one who's in the later stages of transitioning, where they're dressing as that sex, especially if it's a male going to female, there's really not a lot of excuse for not allowing that person to use the female bathroom. And many times that's the accommodation, is to allow that person. Because remember, we have doors. There's not a lot you can see in a women's bathroom. I mean, let's just be realistic about this. You go to Europe, folks, tell you what, there are male and female bathrooms everywhere. in the restaurants and employers, nobody gets really excited because there are doors. You know, in men's bathrooms, from what I understand, there are doors. So if it's a woman transitioning to a male, and they're especially at they haven't done perhaps the complete transition, if they're going to have the surgery, but they are male, so they're going to use that bathroom. I mean, there's just not a lot of excuse anymore for not doing it. I think it's as we more understand the whole transgender and as we become more familiar with that.
I'm just wondering, is there something that you would recommend that, usually when you interview somebody and they leave, you sort of know right then and there whether or not you like them and whether or not you're going to hire them. Well, I feel that way. Is there something in particular that you would recommend that you can put on that application that would protect you? Like, I mean, is there a phrase or something you can say about why you're not going to hire them or why you didn't like them that would help protect you later on if they decide?
Well, first of all, I'd say never write on an application. Ever write on an application. Because you may need that, and you may, and many times, short phrases don't necessarily look like what they really meant. And I mean, I hate to tell you, but there's no perfect phrase here that's going to avoid. The matter is, the easy thing to say is, don't have a discriminatory basis and, have some business-related, non-discriminatory reason, and truthfully record that if you record it. Pardon me?
Instead of the other applicant, you just be better in this.
Right, and you hopefully are able to describe what that better. And it may just be that they click better. Okay, what is that? But be careful with that, oh, I just got along with them better, because you know what that ends up statistically across this country being? The person who looks like me. Person who looks like you. Person who looks like you. You hire white males. You hire white females. And that's traditionally been a problem where we try to hire people like us. But we're thinking, business-oriented, good at what we do, whatever, but really what it comes out to, it's people who look just like you. And that can be an issue. Now, the reality is up here, it's not a huge issue because we don't have a terribly diverse racial group. You go to Manchester, it's a little bit different. You go to Boston, it's completely different. So, it's dependent. But, non-discriminatory business reason is about the best, unfortunately, I can do for you. Okay, if we go to the next page, 4. Now, 4, I gave you a little bit of information, and this is not new, but it's now got this very important increased attention. EEOC has, for decades, said that employers who use arrest records as a filter in determining who they're going to hire, statistically will tend to screen out African Americans. Because at a certain point, and to some extent today, but at a certain point of our history, African Americans, and in certain parts of the country especially, were arrested. Now, I'm not talking about charged or convicted. I'm talking about arrested much more frequently than whites were. So if you use that neutral rule, can't have an arrest record, you're going to screen out African Americans in certain parts of the country. And so what EEOC said was, just don't use arrest records, because what do they tell you? They don't tell you really anything. They tell you they were arrested. Now, when it comes to conviction records, that's something else, isn't it? And certain states have certain limitations. We're surrounded by states that say you can't ask about convictions in the application process. Our state doesn't say that. The feds don't say that. Now, what EEOC has said is, I don't think this is terribly surprising, but what they've said is, if you, the employer, and actually they've been saying this, like I said, for decades, but it's now a big thing. If you, the employer, are going to eliminate somebody as a hire, or fire somebody actually, because of a criminal conviction, then here's what you need to look at. And it's up here in the EEOC guidance, but it's also down here. If you look at the bottom of 4, this is a letter written by somebody who's still in prison to EEOC saying, I'm getting out soon, what am I going to, can employers refuse to hire me because of my convictions? And here's what they say. The employers are supposed to look at the nature and gravity of the offense for which they were convicted, the time that's passed since the conviction and the completion of the sentence, because sometimes the person gets out, but the completion of the sentence isn't. Again, a long-held position, which is there should be some rational relationship between the conviction, the timing, and the job before you say, oh, you know, I won't hire you because of your conviction record. Now, this is another great reason why you rarely want to have across-the-board filtering criteria. You don't want to have a rule that says, I will never hire anybody convicted of a crime. I will never hire anybody who. Those almost always will get you into trouble some way or other. So now, that's EEOC's view on that. And if you look at the number of African Americans who are in prison and are convicted in this country, you can see in certain parts of the country how devastating this would be to have that across-the-board rule that says I won't hire anybody with a conviction. So if somebody has worked, let's say somebody has worked as a truck driver delivering stuff for the last 30 years, and somehow you find out that he was convicted of a crime 30 years ago when he was 18 years old, but for 30 years has had just a fine record, does that really make any difference to you? I don't think so. So just again to remember, that's on EEOC's screen as an issue. This I don't want to spend a lot of time, but the next one on page 5, that is simply that voluntary wellness programs, which are the big woo-woo of 2012 and 2013, and ongoing, voluntary wellness programs do come under the Americans with Disabilities Act even when they're voluntary. So you have to be a little bit careful. It's not true to say that you don't have to do, you can do whatever you want. But it is a good point, at least from EEOC's standpoint, to understand that, and this is at the bottom of that section on page 6, that there are situations where if a person can't meet whatever the voluntary wellness criteria are for a lower premium, let's say for insurance, that doesn't necessarily mean you've discriminated against them because of some disability. So this I would suggest you might take 15 seconds and read it sometime, but it's just really important to remember that this isn't just ERISA. This isn't just the IRS. You also have the EEOC interested in wellness programs. As I pointed out, if we go on to the next issue, the hiring discrimination of the unemployed, EEOC is getting interested in that. A number of New Hampshire bills have been filed. Right now, though, however, District of Columbia, Oregon, and New Jersey, and a bunch of cities in different states prohibit using unemployment as again, screening criteria when you're doing hiring. So where that goes, I'm not sure in terms of other states, but I'm not sure. Does anybody, I don't get the impression New Hampshire's that interested in passing that particular type of law, but I might be wrong. Does anybody have any information? Okay. Well, they may pass it, they may not pass it. But so do be a little bit careful. The studies that have been done, some better than others, have shown, to be honest, a bias from employers against people with long-term unemployment. So when you put two resumes together virtually the same, one showing a period of unemployment and the other not, the chances are you're going to go for the person who hasn't had unemployment, even though most employers can't come up with a reason why that makes any sense. You know, we're not talking about if you're out of IT for 2 years, maybe there's been some huge change, but yeah.
If you have current employment, you have more current experience, and that just generally would speak to that being a better applicant.
Okay, in what job? What job does current employment and experience
Well, I
need
work for
to?
a software company. So
Okay, so that might
yeah.
be. What about a retail store? What about a salesperson? What about an engineer? What about a person in the warehouse?
I
What
guess
about,
my bias would say if they have current experience, I would be more interested.
And that's-
I wouldn't discriminate if they were collecting unemployment, but I just think current experience is relevant when you're in.
right, and again, it's not whether they're collecting unemployment or not, it's whether they've been unemployed. The question always, and that's a great example of, you have a stated bias. So how do you show that the bias is fact-based? If you're hiring a secretary or a clerk or a receptionist, might not matter. For somebody in your area, you can ask questions to tease that out. What if that person, however, has been working in IT as a volunteer for some not-for-profit? Right, right. So you're not using it as a filtering criteria. You're not saying, oh, you've been unemployed, so I'm not even going to consider you. You're using it as it's just something that will cause additional conversation. What have you been doing while you've been unemployed to keep yourself up to speed? So don't make assumptions. It is assumptions in hiring, I will tell you, will get you in trouble. I don't care what we're talking about, faster than anything. And if you're interested in something, ask the question. Don't ask around it. Don't try to be subtle. Don't try to be figured out. Ask the question. Yeah.
Question on a similar situation. A job applicant that can't seem to hold down for a job more than 2 to 6 months. And they haven't been unemployed, but over the last 3 years, they've had 6 different jobs.
Job hoppers.
So
That's a
you
whole
may
different
not
thing.
use that. It's going to be a negative against your.
Oh no, job hopping is always, that's traditionally been used as a marker of an issue. That's different. That's completely different. Okay. The last part that I want to talk about in that sense is the auditing. USDOL, United States Department of Labor, is starting to audit, has been actually auditing health plans, wellness programs. They will let you know. You'll get a letter. That's the Affordable Care Act. It's the Patient Protection and Affordable Care Act. That's the full name. So they want to make sure if your plan doesn't conform because it's grandfathered, they want to make sure, in fact, that you met the qualifications to be grandfathered. If it's not grandfathered, they want to make sure that it's covered. Your wellness programs, they want to make sure that they're set up in a proper way. Okay. For those of you with over 50 employees, anybody here that big? Okay. We've got new family and medical leave policy forms. You should be using those forms. If you use any forms, those are the new ones. Do not use any old ones. Nope, nope, never, never, never. Okay, enough said. You have to also remember, even if you're not covered by that law or you don't have any employees, let's say you got a little facility in Rhode Island that's not covered, you still have to have the poster up, though. Yeah.
I have a situation where, in general, I might have 10 employees.
Mm-hmm.
We run a very large event that just happened in the valley here called Ice Fest, and I end up with 41 employees.
Okay.
So where does that put me on the employee rep? But the 41 employees are only for the 20 maybe for 2 weeks before the event, and then 41 for the event itself, which is only 3 days.
Right.
But you had made the comment that even part-time, you still qualify for the higher
Well,
employment numbers. How does that work out?
You know, so the question is, obviously, the Family and Medical Leave Act, they have really good definitions, and it doesn't apply because you didn't hit 50. So we don't have to think about that. Whether Title VII, et cetera, or the state law, I'd have to look at that, where you have that short term. Yeah, I can't give you an answer off the top of my head, to be honest. I don't know off the top of my head. Yeah, I'm not sure. I mean, the Family and Medical Leave Act, like I said, has specific definitions that are really clear and would tell us, but you have to hit 50, and you wouldn't be covered under that anyway. Okay, lastly, medical marijuana, my darlings. Medical marijuana. Marijuana possession in this country is still a federal violation of federal criminal law. You as employers can take whatever action you want according to your drug testing policy or your drug policy. So if you have somebody who's using medical marijuana, let's say validly, absolutely, the state of the law right now is you can still apply your normal drug testing and drug policy. And if that means they're fired, they're fired. So there's no protection for them in that way. Okay? All right, let's talk about the top 10 list for New Hampshire wage and hour violations. Now, this again is federal law. And a lot of this is state law. A lot of state law looks very much like federal law, but when you're talking about this, we have to be really clear this is state New Hampshire law. So if you have a Maine facility, this isn't what we're talking about. We're talking about New Hampshire, okay? So what's number 10? Failure to have a written safety plan, joint loss management committee, or filing the safety form. The good thing about this, bad thing, is that as of last year, our legislature changed and increased the number of employees you had to have in order to have the committee or a plan. So it's now 15 employees for both. No, you have to have 15. You have to have 15 employees for the safety plan. You know that whole biennial thing. So then you don't have to have a plan. Yeah, look at this. It's very. New Hampshire Department of Labor's website is really easy to use. And you go to the safety part, and it will tell you right there. Or the facts, FAQs, it will tell you right there.
Question. If you have less than 15 employees and have had less than 15 employees and have a safety plan and a sort of smallish safety committee, should you get rid of it?
Well, that's up to you.
Because you're not required to have it.
Right, you're not. If you don't want to have it, then, and you're not required, you don't have to. It depends on.
If there was any liability to having it when you don't have to have it. Because a lot of times with employment law, sometimes you're better without.
And you might find that if you're not required to, that it makes more sense for you. The part that always has worried me is the joint loss management committee. You know, where you get a few management people, a few employees, and talk. And as long as you're only talking about safety, that's not a problem. You start talking about other stuff, terms and conditions of employment, and now we have the National Labor Relations Act being involved. You don't want to have a committee for that. So that would be, otherwise, yeah, it might be really helpful to have your employees talking to you about safety. Employing illegal aliens or undocumented workers. That's really important. So if you have an NHDOL audit, they're going to look at your I-9s, which are federal forms. There is actually a bill, and I don't know where it's going to go, but there is a bill to change the language in the statute, because the language in the statute refers to the Immigration and Naturalization Service, which no longer exists. It refers to forms that do not exist. And it refers to the actual employment of an undocumented worker. There is nothing in the state that, to be honest, says you cannot employ undocumented workers. New Hampshire Department of Labor has interpreted it, that statute that way, but that's not what the statute says. So if you hire your brother that you know, you were there when he was born in Conway, there's no way that person can be an undocumented immigrant, right? Or an illegal alien, whatever you want to call it. And yet, if you don't have an I-9, that, according to NHDOL, is a violation. It's not what the statute said, hence the attempt to make the bill in line. But you should have good I-9s. Everybody knows what an I-9 here is, right? Every one of you has to have I-9s. For every one of your employees hired after, was it November 8th, 1986, I think? So, okay, some of you look a little worried.
Can I just
Yeah.
ask a question? It's saying supporting documents, so they filled out the report. Do I have to photocopy their social security card and keep it?
Absolutely not.
I didn't think so.
No.
So what
You
if-
do it for everybody or you do it for nobody.
If you have seasonal employees and the same people come back year after year, do you have to get a new I-9 every year?
Not necessarily, no. No. But you will eventually.
I'm sorry?
You will eventually. Yeah, you can't do that. It doesn't last forever. Okay.
10 years.
Just to clarify, because the wording on the form is funny about that. You don't, if it's full-time employee, and with consistent employment, not seasonal, not,
Right.
on and off or anything like that, you don't have to have a new I-9.
No,
do you?
no,
I
but
mean,
we're talking about
it-
people who you
it can be
let go.
100 years old, but it.
No, but people you
Yeah.
let go and then
Yeah,
maybe
and
hire
come
back,
then you
that's
are,
different, right.
yeah.
The bottom of the I-9 form actually says that you have to recertify the person is still eligible for employment every 10 years.
Right.
It's right on the
So,
bottom of the form.
but in the,
But what does that mean?
no, it's got nothing to do with anybody unless they're rehires.
Oh, unless they're rehired.
Right,
Recertification.
right.
Well,
That's different.
That's
That-
what I'm thinking.
That's
of.
not, no, once you get one for one of your employees, if they just stay employed, you're good to go. Right. Okay, so but you can see, I mean, that's not the last one, that's the 9th one. Not having basically good I-9s, that's an issue for the state. Failure to pay 2-hour minimum, basically the show-up pay, that's a big one. Right, as Jim said, known as the bad weather rule. So if you don't call your employees or try to get a hold of them, that you're shutting down, for the day, and they show up ready, willing, and able to work, they can get paid 2 hours, or you can have them work for 2 hours if they're there. You can also, however, you don't owe anybody 2 hours if they're only scheduled for 1 hour. That's the only thing. That doesn't mean that, somebody works an hour, gets 2 hours pay. Okay.
So you can, let's say you have a meeting.
Okay.
Lasts an hour, and you can't pay them.
Okay, so somebody has to come back into work
Or-
for an hour.
Yeah, let's say it's somebody's day off, they have
Okay, so they have to come into work if they are scheduled for that. But it's important to schedule them for that.
so if they're scheduled, you don't have to.
That's right, 2 hours. Okay, improper deductions from wages. And Jim has given you down here the 275.48. This isn't from salaries, this is from wages. The way our state works, and many states are like this, the way our states work is you cannot make a deduction unless it's on that list. You cannot make a deduction from wages unless it's on that list. So it's really important that when you say, oh, so-and-so, I'm just going to deduct that from wages, that rarely works unless it's taxes or a couple other things. So go to the list, look at the list and say, aha, here it is. Yeah.
I just want to ask, sort of connected to that, deductions in electronic signature versus paper versions of forms. Does the DOL have a ruling on that? So for example, I have open enrollment coming up. You're going to tell me I can take out your deductions for your health and your dental approved items. Is electronic okay for that?
Generally, yes.
Okay.
But do be able to prove it.
Right.
So if somebody, so depending on what your system is, if you have a system where the person doesn't have a computer, just uses a kiosk, You got to have some mechanism for
Logging
showing
in.
that this person sent it,
Okay.
not that, Joe sent it in for 10 people. Yeah.
I don't know if this was wrong that we did, but if you have an employee that's come to you and is asking for a loan, and you gave them a loan for a certain amount of money, and you had it in writing with their signature that they said, hey, I need $500, can you loan me $500 and take it out of my paycheck over the next couple months? Is that an okay deduction if it's in writing and signed?
The statute has a provision for loans, for bona fide loans. The New Hampshire Department of Labor has given you a form because the employee, this has to be done before the loan is given, and they sign it, and it says when the amount of the loan, when the deduction starts, when it ends, and you have to be careful about the
So there's
percentage.
an official form that you should fill out for
Yes.
that.
Yep. And also, you can choose to arrange with the person that if they leave before it's paid off, you can take it out of the last paycheck. Otherwise, you can't. So these are scheduled deductions, okay? All right. Failure to pay minimum wage for all hours worked. So you at least have to pay minimum wage. Now, we don't have a minimum wage statute in New Hampshire anymore, as you recall. So the question is, well then, why the heck is NHDOL interested in that? Because they enforce a part of the statute that says you have to pay wages that are owed. And if you owe, kind of a double bump issue. So the fact that the legislature got rid of minimum wage, yeah. Okay, so number 5, so middle of the ground here, failure to keep accurate records of hours worked. Most of the time what happens if you have a non-exempt employee, you have to keep accurate records, right? That means they indicate the time they came to work, the time they left. If you have an unpaid lunch, the time they started lunch, the time they ended lunch. Those have to be indicated in writing, in punched, however you do it. So that that's a really important point that sometimes people forget. So there are that actually relates to deductions and it actually relates to accurate records. There are no such things in our state as automatic deductions for lunch. Can't, no way, no how, no. Okay.
What about in the instance where an employee has punched in and they haven't punched out, and you tried to contact them to say, hey, you didn't punch out, we don't know what your hours are, it's payroll time, you can't wait any longer, and you don't know what to pay them.
You have
Can
to
you skip that day?
No, you
or
cannot.
Okay.
No. The New Hampshire Department of Labor has taken the view that you have to pay them what you think might be owed, and then go to them, which will actually cause you to rethink your process on why it's waited till the last day. Because really, sometimes you have to get on managers, because you have a bigger organization, and they are responsible for making sure everybody's time is in. But anyway, you have to pay them what you think is due. If it's an overage, there's a mechanism for an accidental overpayment. They have to sign it. It'll say, again, go to the statute. There's a form that NHDOL has that will help you, and you can recoup it. If it's not enough, then you must immediately, NHDOL wants you to immediately cut them a check, which for those of you who have, payroll services can be an expensive little deal. But that's the way you want to handle that. 4, failure to secure youth employment things. Folks, or they're working too long, there's limitations on hours, or the hazardous environment. Don't forget, we got the way that both federal and state law look at it, you got 13 and 14-year-olds, you got 15-year-olds, you got 16-year-olds, you got 17 and 18-year-olds. Those are all treated differently on what they can do. I really, really question whether you want to be hiring anybody 16 or under. Depending, I know, we have a lot of arguments about what. There are many things that you think of. For example, you can't hire a 15-year-old to mow your grass at your business. That's a hazardous occupation. They can do it at your home, but they can't do it at your business. You can't have a 16-year-old drive one of your trucks, even though they have a license. So you got to be really clear, but the paperwork, which is really just an administrative thing, sometimes falls through the cracks. So make sure before they ever step their little pinky, their little toe into your place, you have all the paperwork, whether it's just the parental or whether it's the parental in the school. Okay. All right. 3, failure to provide written notice of of employees' wage rates, pay period, pay day, general description. What this mostly ends up being is a violation of a regulation, and it's actually one of those that's kind of stuck into one of the existent regulations. And in the state, you have to give the employees a notice of what they're going to be paid, right? So I hire you, you're going to make X amount per hour. I give you a raise. Okay, next week, starting next week, here's how much you're going to be making. Y amount. Okay, each one of those times that I change compensation, the employee has to sign the document. Yeah.
Do they have to have a copy of that, or
No,
can they just sign it?
they can just sign it. They have to sign it.
Is it a form that you have to do, or can you just type it out?
Just type it out.
Print it out?
You can handwrite it out.
Okay.
Just so that prior to the change, you have in writing that they got it. And all the statute says, or the regulation says, is they have to sign it. Yep.
Is that
Regardless of number of employees.
How long is that?
About 4 years.
So do I make a note now that says what each employee is making and have them sign
Well,
it?
since this is going to be on TV, you probably want to call your lawyer, or we'll talk later. Okay. Misclassification, and this is so, we're getting down to the second one, folks. Misclassification of exempt employees, meaning, again, this is federal law. There's no such thing defined in our state law as exempt or non-exempt. This goes to whether you're paying wages that are due. That's how NHEOL becomes involved. So New Hampshire DOL says, well, you should have paid this person overtime because they are non-exempt from overtime. And where do they get that? They have to look at federal law. So federal law says this person is non-exempt. You didn't pay them overtime. You've treated them as an exempt employee. And so that's how they go about this. Don't forget, here's one rule. Here's an across-the-board rule. Being salaried does not mean an employee is exempt. Does not mean an employee is exempt. There are employees that can be exempt who aren't paid salary. There are exemptions where they must be paid over $455, okay? But simply being salaried has never, ever, ever, since 1930-something, meant the person was exempt. It is street law that is completely, totally, and fabulously wrong. Okay. Finally, the number one, and this is huge on a federal level, this is huge on a state level, this is misclassifying people as independent contractors. Here, if there's only one thing you remember, it's this. Independent contractors, like so many of the things we talk about in employment law, is not a choice. It is a legal matter. They are either legally an independent contractor or they're not. They're then more than likely an employee. So when somebody comes to you and says, gee, I'd like to be an independent contractor, the reality is they may not be able to be an independent contractor under our laws. Now when I say, and I know I just did a broad brush sort of statement, but when I say independent contractor, what should be in your mind is which law? We've got one law for unemployment that defines what an independent contractor is. We have another law under workers' comp and the Department of Labor that defines it differently, although it comes out an awful lot the same. But it is a different definition. We have a whole different definition under the Internal Revenue Code. They don't use the 20-point test. So if you're still thinking about the 20-point test, they don't use the 20-point test, and they haven't for a number of years. But they've got this very kind of cool, you'll look at it and say, boy, this looks a whole lot like a rejiggered 20-point test. But anyway, but that's a whole different thing. EEOC uses the National Labor Relations Act case law to come up with who's an independent contractor. U.S. Department of Labor uses a very similar one. So when somebody says, I want to be an independent contractor, the first thing you should say is to yourself is, when I conceive of this position and this person working in this position, is this truly going to meet the qualifications under any of these laws? And here's, if you want kind of a handy-dandy rule of thumb, I'll give you a couple. One is, if they've done that job for you, and now you're going to magically convert them, poof, you're now an independent contractor, never, ever, ever work. Ever. Did I say ever work? It will never work. More than likely. I'm a lawyer, I have to hedge. So probably you can't do that. The great overwhelming probability is you won't be able to do that. The second thing is, if you are hiring them to do what you are in the business of doing, there's a very good likelihood that they're not going to be independent contractors. Now that's a lesser probability, but it's a very high probability. So here's my example. You hire somebody to paint your walls. Now, unless you're a painting contractor, that's probably going to be an independent contractor, right? Because that person has a little company and she goes around and that's what she does for a living. That's what her company does. If you are a construction company, you really need, so you build houses and you hire Diana's roofing company to roof the houses. Okay, Diana's employees probably aren't your employees, right? They're an independent contractor. If it's Joe who runs around, roofing, or Joe and Diana who run around roofing, there's a really good chance they are not independent contractors. Because you're in the business of building houses, and houses need roofs, and they're not acting as independent contractors. Maybe or maybe not. And it depends on, do they have other, and this is important for those of you who have long-term independent contractors, do they work for other people? Are they holding themselves out to the world as independent business people? Independent business people do what? They probably have cards. People have cards. They certainly have a profit motive, so that translates into, is there an opportunity for profit or loss? Or do you pay for everything? You pay for all their expenses. Do they have a website? See, in the old days I used to say, do they have an ad in the newspaper or in the yellow telephone book? Are they even in the telephone book? Or Yellow Pages or whatever you want to call it these days. But when you think about a business, are they being a business? Are they trying to get other work? Here is what is never, ever the determining factor. I don't want to pay taxes. Okay, now, if you say, okay, so what's so bad? What can happen? Okay, in the state, when Governor Lynch, and I've heard of no change in this, when he was governor the last couple of years, what he told all the state agencies were, if you, let's say employment security, if you find that Diana wasn't an independent contractor, she was misclassified, I want you to notify workers' comp. I want you to notify whoever you can. And it sort of goes down. Then, depending on Diana, I refile my taxes because I paid my 7% self-employment taxes that now you, the employer, should have paid. I get what? I get money back because you are going to pay yours, the penalty, and mine. There is no winning at misclassifying. You can put you out of business. You misclassify enough employees, it will put you out of business.
What about a consultant? Does that sort of apply? Like we have somebody we refer to as a consultant, but it kind of sounds like the same thing.
Okay, I'll without talking about your specific cases, when I hear consultants, what I would be interested in is, do they have a business? I mean, right? Do they have a consulting business? Or are you their only and have only ever been and will only ever be their only customer? If that's the case, they're not a business, they're not independent, they're not an independent contractor, they're probably an employee. Again, if the only issue is who pays the taxes and you've sloughed off your obligation to pay the taxes on them, that will never win you anything. And in fact, it'll get you into trouble for your 401k, your health insurance, because you didn't offer that to them, right? it turns ugly in about 12 different ways. So it's one of those issues. I think a couple things here perhaps have hopefully given you something to think about, if not now, in the future. But this may be one of them that you want to look at because it's really dangerous. Yes, ma'am.
What incentive is there for somebody who is misidentified as an independent contractor? Because they report it and now they put their employer out of business.
They can get money. They can get contributions that were there, and there'll be something. Yeah, yes, sir.
Wouldn't it be proof of insurance, somebody that's been in business for X amount of years, when you're doing business with other companies or doing an independent contractor versus somebody that's just got a pickup truck and a ladder rack?
Yeah, those are all sorts, but there's a whole bunch of other criteria.
Right.
Yeah, but that could be part of it, sure.
Right.
You
would be probably responsible for paying, unless you've got something pre-worked out, the taxes on that versus hoping the other guy would, or if it's specifically spelled out, said person is getting paid for doing his business if it's from me, then I'm responsible for paying all those taxes. If I'm paying that guy versus a customer, say we're building a house and one guy's doing the roof and I get another contractor to come in and do that. If I'm still the general contractor, then it's that point with my responsibility versus theirs. Unless the customer's paying them, then it would be their responsibility. That's how I see it being split one way or the other. Because if you're the one making up the whole thing and then you pull somebody in, that's your responsibility.
I mean, it depends on who's the employer. Right. Yeah. Who's the potential employer? They're the homeowner, or the general contractor. I don't know who in that case is. Yeah. Yep.
So if you have somebody who you've been hiring as an independent contractor, and it's been kind of, they have their own stuff, but you want to change them over to an employee, I found that there's this form that's like a reclassification starting fresh form. Do you know which one I'm talking about? I don't remember the exact name.
I like that one, though. Federal or state?
It was on the IRS website,
so it's federal.
It must be federal.
Yeah.
Do you think you should go ahead and fill all that out, or
I
just
can't
switch it
give you
over?
an opinion on that.
You can't give an opinion?
No.
Okay.
I'd have to. I mean, that's a question you need to ask your lawyer on whether you do. I mean, right now, DES, the State Employment Security Agency, wants you to report independent contractors. So you should be reporting independent contractors to them.
Yeah, they're reported, but then
Right.
if you want to change them over, they say we're not going to advertise for ourselves and do our own business for contracting.
Right.
You're
I'd
gonna
rather
change
work
it
for you.
over.
Right.
Yeah.
Yeah.
They wanna work
I'm
for
not
you.
familiar with that, so I can't give you an opinion on that.
Okay.
Yes, sir.
What are the rules for casual labor?
For
And if you hire somebody on a casual,
so just I need you today kind of thing. All the same. In terms of, are you talking about wages and stuff like that? You should have an I-9. You should have, you got to pay a minimum wage, all that stuff. Casual, temporary, full-time, part-time, those for most employment laws aren't affected by how long they work for you.
Something you just said triggered something. The new hire form?
Mm-hmm.
If you change your plowing person, let's say,
Okay.
from
All right.
one independent contractor to another, do you have to plow?
Well, again, I think there's a distinction between if I use what's the name of it? Pinnacle Landscaping to do my plowing at my house. So during, it's a big landscaping company in Hopkinton. They're not my independent contractor. I don't write Pinnacle Landscaping. It's when it's Joe who plows for me.
Yeah.
The guy who plows for me is Bo Woodworking, because he has a company and he bills me Bo Woodworking, and he's got employees and stuff like that. So if I were a company, I would not put him down as an independent contractor. No, and he's not a new hire. He's not anything. He's a company. Just like you don't. If I come and do work for you, you don't put me down as She and Finney Bass and Green as a new hire or an independent contractor. Yes.
We're a moving company, and we hire labor on the road, and we pay them cash. We get a receipt with their social security number, but we don't, and they're usually tipped $60 to $120 per person.
Mm-hmm.
Is there anything I'm supposed to do with them?
Pretty much everything else.
So they're an employee? I'm sorry, don't finish your question.
Yeah, they're an employee.
They're an employee.
Yeah, I mean, you might talk to your accountant about if there's anything, you know, you're not going to be giving them a W-2 because it's not, assuming they don't work.
They're under $600,
Right.
because the government says we don't have to do
Right.
anything with them.
Right.
Anything above $600, we pay $99.
I don't know how they're not your employee.
Okay?
I mean, you're using them?
We're hiring from another company when we're on the road. We're hiring, or we go on Craigslist and we say we want to find some people to help us on a move, unload a truck.
Yeah, I don't know how they're not your employee, though. Maybe there's something in particular. I mean, there are
They're under our workers' comp.
Okay, so you've already said they're your employees for workers' comp, which is smart. Then my question is, why not for unemployment? Well, you'd never be the final employer if you're only using them one day, because even in our state, it's 28 days to be the last employer. You know, again, I'm not sure why they aren't your employees. What it ends up being in terms of some of the obligations may not be there, you know, but as I said up here, I'm not sure why any of the obligations, if they apply, wouldn't apply, simply because you called them casual. Because you've already said workers' comp.
Well, I believe that they're coming under workers' comp. I'm trying to moving companies right now. But,
Well, again, you are in the business of moving stuff and unloading stuff. What do they do? What you're in business to do? Yes. Are they independent business people? No. How are they not your employee under most laws?
well, if it's over $600, I get the company.
Now, that's just whether you have to give them a W-2 or a 1099,
Okay.
or nothing. Whether they have to self-report. That doesn't have anything to do with, you know, whether they're an employee or not. So you might want to talk to your lawyer. You might want to talk to your accountant.
Yeah, this issue is really kind of one of the major reasons that I'm here.
Okay.
We cover all of our employees as employees with workers' comp. The majority of our competition, though, does not, to which they claim they are totally legal to 1099 their employees. So my big question is, what they are doing is they are taking bookings, assigning jobs to their non-employees, providing gear for the participants in the activity. They are covering them by insurance through their own insurance. They're also applying for federal permits, to which they are paying for and providing for their employees, their non-employees. And but yet they're 1099ing these people. Is this a legal thing that they're doing?
I don't know.
How
I
could
would
it not-
question.
How could it not be by
You can drop a
everything you
dime.
said?
You can drop a dime. Anybody can drop a dime on anybody. Say, I don't think, you know, so-and-so, and they'll come out and they'll take a look. But again, it's not,
they're doing
when
all
you
these
say,
things, though, how
I
can
know,
it
but
be
when you
legal?
say 1099 is simply a tax reporting mechanism. It does distinguish between W-2 and 1099. And, you know, if somebody says, oh, I got a W-2, I know they're an employee. If somebody says, I didn't get anything because they only made $200, they don't get anything, you know? If it's a
Everything that you-
1099, I would assume they're independent contractors.
From everything that you've said so far, though, it would say that they cannot do this. But if wouldn't they be required to have their own insurance?
I think there's a couple things. Maybe they're hiring through a temp agency.
No, that's not the case.
Okay. I'm not sure. I'd have to think about it. It doesn't. If I were trying to set up a business like that, I would have to look at all the different laws and say, does that apply? Now, there are some. You have to be careful because unemployment in workers' comp does have a little list of exceptions that are not considered employees for purposes of, or excluded from who needs to be covered. But do remember something also. The cost of the misclassification, for example, under workers' comp, can be quite high because you'll actually get fined.
This is a major issue. They're not paying workers' comp. We
Yeah,
are. It's a
again,
huge expense.
the agencies can look at it. You can talk to your lawyer and have your lawyer make some, determination under each one of those laws, are they? But the question is, who's going to do anything about it? The agencies are the ones that will do something about it. So it may be okay, maybe not okay. I would
Very
have to
simple and
question.
straightforward.
Just like
I want to thank Diana very much.
Thank you very much.
For
That's
coming
very
up
sweet.
yet again.
Thank you. Thanks.
And
I hope this has been helpful.
I also just want to mention that next month we have Steve Norton coming up. He is the director of the New Hampshire Center for Public Policy, and they have been doing a survey of economic indicators to be able to make informed predictions about how our economy will go. So I hope to see you all then. Thank you.
Valley Vision, local focus community service television. Channel 3 for Mount Washington Valley and Western Maine.
Which you do all the time, and as well as the town assessor, the town manager sees people all the time. The four-wheel drive vehicle that we're talking about, although I don't know where it is now, but when I looked at it, some time ago. It had a lot of miles on it, it had a lot of police wear and tear on it, but it had no rust on it either. Which, you know, I felt as though that with a few $1,000s, we try to patch it together with a few $100s and pass it off to town employees. In my mind, it should be a few $1,000s to get it so it looks and presents its way and works the right way. And I'm not sure why that cannot be done, or is never done. You know, again, you and I have had this conversation many times. You look at a vehicle that's met its life expectancy, you decide right away, is it full of rust or does it have no rust, you know? Mm-hmm. Is the motor need to be replaced, the transmission, things of those natures, and you know, again, this vehicle had no rust on it, it just had a lot of miles and a lot of wear and tear, but I think it could have been salvaged. And I think if I remember correctly, you know, we've had the town assessor towed out of somebody's driveway before because we sent them in a vehicle that broke down in somebody's driveway. We've got stuck in people's driveways before. You know, you guys are going out into places where people live, and a lot of the people in this town live in remote areas. And
we can look at, you know, we can take a look at the costs. I mean, you know, we like leasing or buying a 2 or 3 year old mid-sized kind of sedan and just see what.
I know you don't like. I mean, you've been really good about not wanting to have a company car, but I'm just a believer that if we can get something rehabbed at a reasonable cost, then just a thought.
Yeah, we can take a look at some numbers for you. Be happy to do that.
Okay. You're up. And you'd like to do highway first? You pick it.
Alrighty, highway it is. And gosh, I don't have anything really to draw your attention to other than the increase is the request is 1.3%, which I'm sure you'll find is well below inflation for the same period. Open to questions.
Stacy.
Okay, under highway inventory, we budgeted 4,000 and spent 22,209. Previous year you budgeted 4 and spent 10. Why hasn't that line item gone up?
Well, if we go back over time, we see that everything bought into highway inventory gets charged out to the various departments. So highway, solid waste, police, school, etc. And so theoretically, highway inventory should always be 0. But it's not. And we look at how much we spend and we budget the number based on what's an acceptable percentage of the